Welcome back to the Deep Dive. Today we are tackling a subject that, quite frankly, usually comes with a heavy sigh attached to it.
Oh,
It's
yeah.
massive, it's intricate, and it governs literally everything we do in this country, yet most of us, well, we haven't really looked at it since high school civics class. We are talking about the Indian Constitution.
It is the elephant in the room of Indian democracy, for sure.
It really is. And I'll be honest, when I first looked at the stack of materials for this dive, my immediate reaction was, oh boy, here we go.
I get that.
I think for a lot of people, the Constitution just feels like this intimidating, dusty list of rules. You picture
Yeah.
this massive book filled with articles, clauses, subclauses.
It feels like a mountain of data you just have to memorize.
Exactly. Just pure memorization.
That is the most common reaction. You see the sheer volume of the text. It is one of the longest written constitutions in the world, after all, and your natural instinct is to treat it like a phone book.
You just look things up.
Right. You think it's just a directory of rules to be stored in your brain. But the fascinating thing about the material we're exploring today is that it completely challenges that view.
That's what pulled me in. The argument here is that if you're just memorizing article numbers, you're actually missing the point entirely.
The whole point.
The material presents this not as a list, but as a design.
Exactly. It's a shift in perspective. Instead of looking at what is written, the specific text of Article X or Y, we need to look at why it is written.
So, from rote to concept.
We're moving from a rote memorization approach to a conceptual one. Think of it less like a list of instructions and more like a philosophy or a logical framework.
Framework is a word that kept popping up in my notes. The idea is that the Constitution isn't just a grab bag of random laws thrown together.
No, not at all.
It's a planned structure.
It is deeply structural. I mean, think of it like building a skyscraper. You don't just pile bricks randomly, right?
Of course not.
You lay a foundation, then you build the pillars, then the roof. The Constitution works the same way. The early parts of the document lay the groundwork for the later ones.
So you can't just jump into the middle.
You really can't. You cannot understand the powers of the president, for example, if you don't first understand the fundamental rights of the citizen. One supports the other.
So it has a narrative flow, in a way.
It does. It tells a story about how the state is supposed to function. And this is why the material emphasizes that this knowledge isn't just for, law students or people trying to crack civil service exams.
Right, because usually when people talk about constitutional law, they're talking to lawyers. But this affects everyone.
Precisely. If you are a citizen living in this house, you should probably know which walls are load-bearing and where the emergency exits are.
That's a great way to put it.
Understanding the logic of the design makes the document accessible. It turns it from dead text into a living operating system for the country.
I like that operating system analogy. And that actually brings us to a specific concept that is central to this whole discussion. The material introduces a term that sounds very serious, very German, and very intense, the Grundnorm.
Ah, yes, the Chalcedonian concept, the Grundnorm.
It sounds like the name of a final boss in a video game. You must defeat the Grundnorm. But in plain English, what are we actually talking about here?
It does sound imposing, but the concept is actually beautifully simple. In legal theory, the Grundnorm is the basic, fundamental norm from which all other rules get their power.
The master source.
Think of it as the master source, yes.
So if the Constitution is the Grundnorm, it's the battery powering everything else.
That's a good way to look at it. Or, going back to your operating system idea, the Constitution is the OS. Every other law, whether it's the Motor Vehicles Act, the tax code, or a contract law, is just an app running on that OS.
And what happens if an app crashes the OS?
The OS kills the app. That is the power dynamic here. The material makes a very specific point. Every law, for the time being in force, derives its authority from the Constitution.
So a law only exists because the Constitution says it can.
Exactly. If a law exists, it's only because the Constitution allows it to.
So let's say Parliament passes a law that says everyone has to wear blue hats on Tuesdays, and the Constitution says you can't force people to wear hats. Then the law is, what? Illegal.
It's void. It's unconstitutional. Because the Constitution is the Grundnorm, it has absolute supremacy. If any law violates the core principles, especially fundamental rights,
It just can't stand.
it cannot stand. It doesn't matter if the Parliament passed it unanimously. If it contradicts the Grundnorm, it's gone.
This connects directly to the role of the courts, right? Because you can't just have a book sitting on a shelf saying, I'm the boss. You need someone to enforce it.
Correct. The document needs a guardian. In our system, that is the judiciary, specifically the Supreme Court and the high courts. Their job, under this framework, is judicial review.
So they're the referees.
They compare every challenged law against the Grundnorm.
So when we see news headlines about the Supreme Court striking down a law, they aren't just giving their opinion. They're basically acting as the antivirus software.
That is a perfect analogy.
They found a bug that threatens the system and they quarantined it.
They are ensuring the hierarchy remains intact. The river cannot rise higher than its source. The law cannot be more powerful than the Constitution that authorized it.
Okay, so we've established the foundation. Constitution equals Grundnorm. But the material we're looking at today doesn't stop there. It teases a roadmap of doctrines.
Yes.
And this is where I think people usually get lost. We hear these terms thrown around on the news or in legal dramas, basic structure, doctrine of Eclipse, and they just sound incredibly academic.
They do.
But the material suggests these are actually practical tools for understanding how the machine works.
They are. These doctrines are essentially the interpretative tools the Supreme Court has developed over decades to solve specific problems. They aren't just fancy Latin names. They are solutions to constitutional crises.
Let's dig into a few of these because the names are evocative, but I want to understand what they actually do. Let's start with one that sounds like a sci-fi novel. The doctrine of Eclipse.
It does sound dramatic, doesn't it?
Is the Constitution blocking the sun? What is happening here?
It's actually a very visual legal metaphor. Imagine you have a law that was written before the Constitution existed, say back in 1940.
Okay, so a colonial law.
Right. Then, in 1950, the Constitution comes into force, guaranteeing fundamental rights like freedom of speech. Now, suppose that old 1940 law violates freedom of speech.
So the Grundnorm says no, but the old law is still on the books.
Exactly. The doctrine of Eclipse says that the old law isn't necessarily dead or wiped off the books permanently. Instead, it is overshadowed by the fundamental right.
Oh, okay.
It goes into an eclipse, it becomes dormant or unenforceable because the fundamental right is blocking it.
It's sleeping.
It's sleeping. And here is the kicker. If the Constitution is amended later and that shadow is removed, if that specific restriction is lifted, the old law can wake up and become active again.
That is wild. So it's like a vampire in a coffin waiting for the sun to go down.
That is a slightly more Gothic way to put it, but yes. It explains how laws can be valid but unenforceable simultaneously. It solves the problem of what to do with pre-constitutional laws.
Okay, that makes sense. Let's try another one from the list. The doctrine of severability. This one sounds surgical.
It is surgical.
Wow.
This answers the question. If a legislature passes a massive law with 100 clauses, and one of those clauses is unconstitutional, do we have to throw the entire law in the trash?
Right. Do you burn down the house because of one termite?
Exactly. The doctrine of severability says no. You try to sever or cut out only the bad part.
Just the one clause.
If you can remove the unconstitutional clause and the rest of the law still makes sense and can function, you keep the rest. You only strike down the bad apple to save the basket.
But I assume there's a catch.
There is always a catch. If the bad part is so mixed in with the good part that you can't separate them, if the whole law is rotten because of that one core idea, then the whole thing has to go.
So the court is basically performing surgery. We can remove the appendix, but if the heart is bad, we have a problem.
Precisely. It's about saving as much of the legislation as possible while protecting the Constitution.
Okay, I have to ask about my absolute favorite term on this list. It sounds almost poetic. Colourable legislation.
Ah, yes. This is a classic.
It sounds like a law that's pretending to be something it's not, like it's wearing a disguise.
You are spot on. That is exactly what it is. The core maxim here is, what you cannot do directly, you cannot do indirectly.
Break that down for us.
Okay, let's use a parenting analogy. Imagine a parent tells their child, you are absolutely forbidden from watching TV.
Clear rule, no TV.
Right. So the child goes to their room, pulls out an iPad, and watches Netflix.
I see where this is going.
The child says, but I'm not watching TV, this is a tablet. Technically, they are following the letter of the order, but they are violating the spirit or the intent.
And that's colourable legislation.
That's it. It's the government trying to pull a fast one. In India, we have a federal structure. The center can make laws on some things and states on others.
Right, the different lists.
Sometimes a state wants to make a law on a topic it's not allowed to touch, so they draft a law that looks like it's about a permitted topic, but in reality, the effect is on the forbidden topic.
They color the legislation to look legal.
And the court's job is to wash off the paint. The court looks past the disguise to the true nature of the law. If they find it's just a trick to bypass the Constitution, they strike it down.
It prevents the legislature from cheating the system.
It does.
I love that. It really shows that the Constitution isn't just words on paper. It's about intent. It's about preventing power grabs.
And that leads us to the biggest doctrine of them all, the one that really defines modern Indian democracy, the basic structure doctrine.
The heavyweight champion.
The heavyweight champion. This doctrine basically says that while Parliament has the power to amend the Constitution, they can change articles, add new rules, update things. They cannot alter the basic structure or the essential features of the Constitution.
So they can renovate the house, they can paint the walls, maybe even add a room.
But they cannot blow up the foundation.
They can't touch the core.
They cannot take away judicial review. They cannot destroy the secular nature of the state. They cannot remove the democratic process. These are the basic structure. Even if Parliament votes 100% to do it, the court says, no, this is the soul of the Constitution. You cannot touch it.
That distinction between the body that can change and the soul that cannot is fascinating. And it brings us to the final big theme of this deep dive. The material uses a metaphor, moving from skeleton to spirit.
Yes, I like that one.
The skeleton is the articles, the parts, the schedules, the rigid stuff. But the doctrines we just talked about, that's the spirit.
That is where the life is. If you only read the text of the Constitution from 1950, you might get a very rigid view of the world. But society has changed drastically since 1950.
I mean, completely.
Our values have changed. Technology has changed.
So if the Constitution was just a static block of stone, it would have cracked by now.
It would have shattered.
Right.
That is why the concept of the living document is so critical. The Constitution evolves. It doesn't evolve just by changing the text, though amendments happen, but it evolves through interpretation.
This is the role of the Supreme Court again.
Yes. The court interprets the text in light of modern times. For example, the right to privacy. You won't find the words right to privacy written explicitly in the 1950 text of Article 21.
Right. They didn't have smartphones back then. They weren't thinking about data protection.
Exactly. But the spirit of Article 21, which protects life and liberty, is broad enough that the court could say, in the 21st century, you cannot have liberty without privacy. Therefore, privacy is part of Article 21.
So the text didn't change, but the meaning expanded to fit the new reality.
That is the magic of the living Constitution. It allows the past to speak to the present without holding it hostage. It moves from a rigid skeleton to a breathing, adapting spirit.
It really changes how you feel about those heavy law books. It's not just a list of do's and don'ts. It's a story of a society trying to figure itself out, adapting its rules while trying to keep its core values, that basic structure intact.
A story that is still being written every single day.
So let's recap what we've unpacked today. We started with the idea that the Constitution isn't a random list. It's a logical architectural design.
A design where the Constitution acts as the Grundnorm, the supreme authority, and the source of all legal power.
We talked about the guardians of that galaxy, the courts, using judicial review to strike down anything that clashes with the Grundnorm.
And we walk through the toolbox they use, the doctrines, the doctrine of Eclipse for overshadowing old laws, severability for saving the good parts of a law.
And Colourable Legislation for catching the government in a lie.
Exactly. And finally, the basic structure, the unchangeable soul, and the living Constitution that allows the body to adapt to the times.
It is a delicate balance between stability and flexibility.
It is.
The advice from the material was pretty simple. Keep this foundation clear. Don't get lost in the article numbers yet. Understand the logic first, because the concepts only get deeper from here.
If you understand the why, the what becomes much easier to remember.
I want to leave you with a thought today, specifically on that living document concept we discussed. It sounds great. Flexibility, adaptation. But think about the tension there. If the text is fixed ink on paper, but society keeps changing and the courts keep reinterpreting the spirit to bridge that gap, at what point does interpretation become rewriting?
That is the million-dollar question. Where does the judge stop and the legislator begin?
It's the tension that defines our entire legal system, and maybe there isn't a perfect answer. Something to mull over until next time. Thanks for listening to this deep dive.
Thank you.